you're stealing. And when they start to think you're stealing, then they're going to hire attorneys. They're going to object to your executorship. They're going to demand accountings. And the motion practice and the motions start to fly. And then the court has to take time to go through those, to have hearings, and ultimately to make rulings. And until those rulings are made, a lot of times nothing further can be done in progressing the administration of the estate, from the marshaling of the assets to the paying of the debts to the administration. So you've just created a huge, it's like a self-inflicted wound. You've created a huge hurdle for yourself that now you have to overcome. And lastly, as part of that communication, I think it's important for executors and, quite frankly, for beneficiaries and beneficiaries and heirs to think about compromise. These assets are generally not passing to strangers. They're passing, from family members down to other family members, usually in the next generation. We're talking about generational wealth going from parents to children. And as part of that process, parents make the best decisions that they can make. It's not always the right decision, and sometimes over time situations change and it may not be the best decision at the time that the decedent passes, but it's the decision they made. It's the best decision they made at the time they made it. And if the beneficiaries and the heirs are unhappy with that decision, the family should get together and try to work on a compromise. And I think it's up to the executors and the administrators as the leaders, if you will, the executive that's governing this probate process, to try to facilitate that so that when you get to the finish line, when you get to the point where you're finally trying to distribute those assets to the beneficiaries or those assets to the heirs, that you don't get another flurry of motion practice, another flurry of objections, a will challenge. And, again, it stops the court in its tracks. They've got to conduct hearings. They've got to make rulings. And ultimately, no one in the family gets the assets until there's a ruling. So the whole process slows down. So that's really kind of it for me. I went generally through the process, if you will, of probate in a very sort of large overview, and then I tried to go through in some more granular detail some of the issues that I see cropping up during the course of administration. And then lastly, I tried to, I think, tell you a little bit about some of the problems I've seen during the course of my lawyering career in helping to facilitate the administration of these estates. So at this point, I would, I guess, see if anyone has any questions for me.
We have 2 questions from online before we go to St. Croix and then St. Thomas.
Fire away.
Who pays the cost of probate? Is it shared among the parties who are probating the will? Who pays the cost of probate? Is it shared among the parties who are probating the will?
The probate estate pays the expense of the probate, and so ultimately that expense comes out of the assets of the estate, and that is then shared to all the heirs or the beneficiaries. So let's say the cost of probate is $10,000 and there's $50,000 in assets in the estate. The final adjudication will basically say there's $50,000 of assets, there's 5 kids, each of them is going to get $10,000, but then we're going to subtract $2,000 from each of them to pay the costs of the probate, so they each get $8,000.
And which process prevents probate?
Which process prevents probate? There are many mechanisms to prevent probate. Having a trust and putting all your assets in the trust will help you to avoid probate. And now we have a lot of really wonderful mechanisms. In 2019, the Virgin Islands Senate passed a Transfer on Death Act. Rosalie Simmons mentioned it. And you can now transfer a deed from yourself or your spouse back to yourself with a transfer on death to your beneficiaries. And then your primary asset, your home, and also secondary assets like cars, can be transferred at death by the mere recordation of a death certificate. So those 2 prime assets can transfer outside of probate and outside of a trust. Very powerful tool.
Okay, St. Croix, if there's any questions? Come.
Good evening.
Hi, good evening.
Not so much of a question, just more of a, I guess, follow-up to you answering that the estate pays for the probate. However, it's really like an upfront. That comes out at end, but if you don't have the money upfront to afford those fees going forward, it really doesn't get resolved, correct?
You are correct. So just to clarify, I mean, over the course of the entire probate, the expenses come out of the net assets. But if the estate is not liquid, then unfortunately someone's got to come up with the money, and usually it's the executor. So unfortunately, family members or the executor are going to have to pay upfront for the costs and attorney's fees. And then they file what's called a creditor's claim for the costs and attorney's fees that have been incurred. The court will generally grant that, and then they'll get reimbursed for any costs that they fronted, if you will. But that is another challenge, and a real challenge. Unfortunately, I would say probate is not cheap. I would say we've heard the horror stories on 20 or 14 years, but I think realistically, on a simple estate plan that's well prepared without a whole lot of motion practice, you're looking at 18 months to 2 years here on St. Croix. I've heard it's longer on St. Thomas, but I'll let them discuss that. So there are costs, and if the estate is not liquid, those costs unfortunately have to be borne by one of the more liquid heirs or beneficiaries to be recouped towards the end. And I guess that, to answer your question a little more, that could be one reason for potential delay in filing the probate.
Scott, how can we improve probate in the Virgin Islands? It sounds really messy in general. Are there other laws, other ways of doing this out there that we just haven't incorporated?
Our Senate is trying to address some of these issues, as Nadine suggested. I think, especially on cleaning up some of the older and some of the messier estates, it's the court would benefit, I think, from a little more manpower. Unfortunately, every time a motion is filed, one side files a motion, the other side files a response, and then the initial movement files a reply. So you got 3 documents. Sometimes those documents are 15 or 20 pages each, so you're looking at 60 or 70 pages of documents. Sometimes there's attachments of hundreds of pages, and the court needs to get through those in order to make rulings. And if there's 20 or 30 other cases in front of them, it just takes time. I think manpower helps. Certainly, there's a lot of very standardized estate laws that exist throughout the states. Those can be looked at and incorporated here. I think just seeing this many people here in person on St. Croix, as well as those that are online, I think should make the Senate and should make the government take notice that this is an issue of real concern for all of us, because if we're stuck in probate and nothing gets moved, it's not just a problem for your family or your family, it's a problem for our community. I don't know if that answers the question, but those are my thoughts.
I'd like to turn to the island of St. Thomas now, and there are some questions there. St. Thomas.
The question is, what mode of transfer?
Well, I thought there were questions there.
Louder? What mode of transfer is necessary in this situation? Grandmother passed, 6 children, final adjudication was filed. Now, 4 children have passed. You have 1 heir, 1 incapacitated of the 2. So what mode of transfer can you do at this stage?
We didn't hear your whole question. Could you please ask it again?
Grandmother passed, 6 children. Final adjudication was filed. Now, of the 6 children, 4 have passed. 2 are alive. 1 is incapacitated. The other is good. But what form of transfer can be done for the grandchildren at this stage?
Was there a will, or was there...
No will, no
did
trust.
the person die intestate?
No will or trust.
All right, so the person died intestate, so the law of descent and distribution would apply. And did the children that passed pass before the grandmother or after the grandmother?
After the grandmother. So the real
All
question
right, so
is
then...
the real question is the incapacitated heir that's alive, along with the other that's good. Should they? How do they get it on to the grandchildren at this stage?
So I'm going to try to answer the whole thing. So there was 6 grands, 1 is alive, 1 is incapacitated, and the other 4 have passed.
No. Grandmother, 6 children. Final adjudication was filed for the 6 children. Now 4 have passed. You have 1 incapacitated after the final adjudication, and 1 is good. So you've got 2 children, 1 incapacitated, and 1 good heir. What do you do?
So the shares that go...
Go ahead.
So the shares that go to the 4 deceased children would go to their estates. So unfortunately, you can't distribute anything until those estates are opened, either by yourself or by someone else. With regard to the incapacitated person, perhaps a guardian needs to be appointed, or perhaps there's a power of attorney, and the assets can be distributed to their power of attorney or to their guardian. And then to the remaining, they would simply get their share.
I want to remind everyone that this conference provides information and not legal advice.
And I guess I was stating that more as a hypothetical than as a... no names were mentioned, so I was addressing it as a hypothetical.
Yes, I understand, and that's a situation for many of us, so I'm allowing that question, but I just want to make sure that we are all clear.
And that is not an uncommon fact pattern.
Right. So information, not legal advice, okay? All right, thank you so much. We have time for one more question from St. Thomas.
All right. Hi.
No?
Could you, hello? Can you hear?
Yes. Yes, we can hear you.
Could you share any advice on ways one can prep or prepare to be an executor?
I guess I would suggest that you bone up on your communication skills. You develop, you keep your relations with your family close, and you bone up on your accounting. It's the one skill that most people don't have, and it's the one skill that we really need every 3 months. And if you don't file them, the court will get very upset.
So,
Most of the time, I would say that executors are quite often guided through the process, either by an attorney. There's also self-help books. I think there's a Executors for Dummies book out there, one of those yellow books. I have one in my library. I share it with my clients. I've looked at it a few times too.
so we'd like to thank Attorney McShane for now. He will be back up when we do our last round of questions.
Thank you, thank you.
So a couple things before we get to our last presenter. I wanted to make sure that I acknowledge staff members on the island of St. Thomas. In the room would be Mr. Raheem Smith, Enterprise Zone Specialist, Shayla Anthony, compliance and program manager. We have 2 marketing people, Kyle Thomas and Simile George, in the room, as well as an accountant from the Economic Development Authority, Ms. Jana Kami. So I just wanted to acknowledge them. They're on the island of St. Thomas, making sure that things go smoothly. So thank you. I also would like to acknowledge someone who has been at the forefront. The Enterprise Zone does a lot of work within the community. And we have a grant that we have received to assist people in a pilot program to do their estate planning. So once we're finished with this pilot program, we will have the ability to publish to the general public ideas of how to go forward in dealing with your estate planning issue. Always calling my office and always in the forefront of looking forward and trying to assist the people of St. Croix, especially the historic town and the enterprise zone of Christiansted. We would like to recognize Ms. Vivian Flood today as someone who is always pushing us to do more and do better for the people of St. Croix and the Virgin Islands.
I had to say something. I was not expecting this at all. I do talk to her frequently, but I am humbled because the telephone calls are for moments like these. And there are not many of them. So, but we appreciate that anything we can do and anything I can do, I will continue to do, because this is all of us island home.
Thank you, Ms. Flood. Okay, we have one other speaker before we ask questions of the general group. Anna Paiwanski. Trusts. And I titled her speech, which this is not how she titled it, but I titled it Speaking from the Grave. I remember an attorney out of St. Croix a very long time ago saying that if you want your stuff done the way you want it done once you've passed, you should do a trust. And so I would like to welcome to the podium Attorney Anna Paiwanski.
Thank you, Nadine. Thank you, everyone, for coming. Economic Development Authority, thank you for having this, and kudos for getting us to where we are today. We've been through a lot of topics tonight, so I'm going to go fairly quickly, so brace yourself. We're going to start off with just a basic description of what is the difference between doing a will or a trust. Yes, that one. So a will is basically deciding what happens after you've passed.
Anna?
Yes.
Hold on one second. We're not seeing the PowerPoint on this side. And so, hold on one second. Hold on. We're trying to put up the presentation. Hold on one second. Awesome.
Got it?
Okay. Got it.
Okay, good.
No, we just lost it. We just lost it.
All right, well.
We have it now.
Okay. So a will is after you've passed. A trust is a bit of a different animal, because a trust, first and foremost, takes care of you during your lifetime. And I stress this because some of the questions that have been raised this evening pertain to people who are incapacitated. Your trust takes care of you until you pass. If you're unable to take care of yourself, your trust is designating who has the power and ability to take care of you. As we say, to keep you in the lifestyle to which you are accustomed. Unfortunately for all of you, you've been listening to 3 attorneys this evening tell you some horror stories, and we all have horror stories. We've been in this business for too long. And I can tell you that there are a lot of people out there, even your dearly beloved children, who after you've passed or while you're incapacitated may be thinking more about themselves than you. And the important thing is to make sure that the person or people that are taking care of you during your lifetime, when you are no longer able to do so, can manage your funds so that you are kept in the lifestyle that you have been accustomed to. Either A, not taking care of you and saving money for your beneficiaries, or simply not managing your funds well so that the funds that were planned for your lifetime get used up faster. A trust gives you that ability. A will doesn't. A will just takes care of what's left after you've passed. Now, those are the basic differences in terms of a will and a trust. I think I have a little machine here that's going to get me to the next screen. Next. Okay. So why should you have a will? One of the main reasons in the territory for why you should have a trust is to avoid probate. That's one of the main reasons in this territory. There are people in the states that they don't necessarily have to have a trust because the probate process is relatively painless and quick. And their heirs and beneficiaries can get their assets quickly. I have unfortunately had scenarios where the probate has taken so long the beneficiary passed before they got what they were supposed to get. So in the sense of avoiding the probate process, that is critical. But the other thing that the trust helps you do, my crystal ball is broken, I'm not sure if you all still have one, but you may designate somebody as a beneficiary and they may predecease you. So then what happens? A trust can give you options. A will doesn't give you as many options. So you can say, well, if this person predeceases me, then I choose for this person to get whatever that asset is. It gives you that flexibility. It also gives you the flexibility of liquidating those assets, which if you sell your home before you pass, then when it comes to a will, there's no home to probate. But you have the ability within a trust to change who the beneficiaries are. If it's a revocable trust, you have the ability to make concessions. You may have a particular person who you want to care for during their lifetime, that in addition to caring for you, you can care for the estate. The trust cares for them as well. You have a lot more flexibility in what you can do with a trust, and you can always revise it. You decide you don't like the way that particular beneficiary is behaving, or you decide you just don't like them, period. You change it. Give it to somebody else that you do like, You have that flexibility. The other flexibility you have is that you don't have to give it to your children just because they're your children. If there's somebody else you want to give it to, you can do that. You can give it to your church. You can give it to whoever you want. There's nothing to argue over who you decided to give your stuff to. And it also allows you to take control, as it says. It lets you plan for the possibility that you would be incapacitated. A guardian doesn't need to be appointed because you've picked the people that you know are going to make the best decisions for you. during your lifetime to take care of you first and foremost. And if taking care of you means liquidating all of your assets so that you can be taken care of, then it has that ability to do that. Next. Next. Okay, special advantages for Virgin Islanders. If you are a Virgin Islander or are naturalized in the Virgin Islands, either one, born or naturalized, your children inherit tax-free. Inherit tax-free, which means that if your spouse isn't, then you can put your assets, Virgin Islands assets, in your trust and non-Virgin Island assets in your spouse's trust. That way your children inherit tax-free. Or you don't give it to your spouse, they just have it during your lifetime, and then it goes to your children who inherit tax-free. That is only in the Virgin Islands. That's not assets outside of the Virgin Islands. I always recommend that aside from talking to an attorney, you talk to a CPA or an accountant, because there's tax implications for where your assets are, depending on your tax bracket, depending on this and that and the other thing. So you want to have a conversation with the CPA so that they can tell you, well, in this case, if you put that asset in your trust, it's going to be taxed at a higher bracket. Maybe it will, maybe it won't, but you want to ask an accountant that question. You don't want your heirs to find out that by doing something or not doing something, you've raised the taxes that they're going to be exposed to. So I always recommend that they have those conversations. We've had some conversations here tonight about deeds and pay on death or a transfer on death. And there may not be a tax consequence for that. There may be some other disadvantages, which we might get to if you remind me, but there's tax implications depending on who gets what. So have those conversations. Don't just have a conversation with an attorney. Not every attorney is an accountant. So don't make that assumption. Let's see if this works. Next. Okay, revocable and irrevocable. A revocable trust you can change, just as I was describing before. You can change who gets what, you can change who takes care of you, you could make all kinds of changes, add more assets, do all of those things, change beneficiaries and all of those things. An irrevocable trust is set in stone. You don't change it. Now, some people are looking at me like, why on earth would you do that? There are some tax benefits to having an irrevocable trust. Again, have a conversation with the CPA as to whether or not that is something that may be worthwhile. Next. Okay, what should I put in my trust? Everything. I tell people when I do these presentations, the last thing you want is to leave out Granny Sugar Bowl and have somebody go to probate over Granny Sugar Bowl because that's what they want and spend more money than Granny Sugar Bowl was ever worth in anybody's imagination because it wasn't there. Now, I'm not saying you have to itemize everything. You can say all of the things in this home, or you can take on the adage, a picture paints 1,000 words. Take pictures. Then once you have the pictures, you've got paintings, you've got crystal, china, whatever you've got, records, whatever it is, decide who gets it, okay? That makes it easier. And if you don't know, you may just say, well, sell it and then just divide the proceeds. But but identify everything somehow. You know, the easy things, bank accounts, property, a vehicle. You know, the bigger things people tend to think of more, but you may have a savings bond that you got 20 years ago that you don't even remember. Think about the things that you have, and think about who may want those things, but try to include everything. You don't necessarily have to itemize the sugar bowl, but you can say everything in the kitchen, you know, divide it up, however you decide to divide it up. But it's important not to leave things out. I literally did a trust where the person who was doing the trust had a dog. And it was very important to them that their dog got taken care of. We had a picture of the dog. We had a whole financial plan for the care of the dog because this was important to them. But I say that because there are things which, like we talked about earlier, you may not necessarily think it's valuable, but it may end up becoming the most expensive thing you have in your house because it's going to cost $10,000 to probate it. So when you go in, pictures are really easy. Put your jewelry down on a table and take pictures. It's easy. Take pictures of the artwork and whatever you inherited from your parents and grandparents, just take pictures. You have no idea who's going to fight over it later. Next. Okay, what decisions, you go. What decisions do I have to make regarding the trust? Who's going to be the initial trustee? Normally it's you, but you may know that you've got some condition that's going to make you incapacitated in the near future. You may identify someone else. Who you identify as your successor trustee is critical. Because remember, that person is taking care of you during your lifetime if you're incapacitated. Pick people that you know will do what you want, okay? It's very important. Sometimes it's not a family member. Sometimes it's your best friend because you know you can trust them to do what you want. But make sure that you pick the people that are going to carry out your wishes. Choose wisely. Who is cared for during your lifetime? It may be you, it may be a spouse, it may be both of you, it may be a child with a disability that needs special care. There may be a relative of yours that you want to care for because there's nobody else caring for them. Whoever you want to take care of, you're going to identify those people in your trust. Okay, in some cases, if you have young children, you want to make sure that they're cared for and that their schooling is paid for, etc. You're going to want to give the instructions as to what you want done for those people that are minors and need care, and what they want for regular schooling through high school, college, etc. And your spouse or loved one that you want cared for during your lifetime and during theirs. Sometimes what you do is you set it up so that even if you predecease that person, the trust still takes care of them until they pass, and then it gets distributed to the beneficiaries. Who's going to make medical decisions? This is also extremely critical. I've had situations in which people have picked someone who was going to make their medical decisions, and then when they got sick, they realized that person's going to do what they want, not what I want. And this is very important, and everybody is different. Some people want to be on life support until a cure comes along. Some people don't. Some people want... You know, there's some family members that don't want you taken off of life support, but that's what you want. And they make the decision that they want and not you. When you make these decisions, these are critical decisions. You want to make sure that the decisions you're making, the people that you are designating to make those decisions, make your decisions, not their own, and that you can trust them enough that they will do that. Okay, so it's very important who you pick. And again, it may not be a family member. Okay, so as I said earlier, you can designate who gets something, and then you can designate what happens if they don't survive you. Okay, and you have the ability to do that. Sometimes when I sit down with people, I tell them I may sound like the Grim Reaper, and I kill everybody off, and then I say, okay, so after all of those people are gone, then who? And I've had situations where this has literally happened. Everybody died in a terrible accident. And then who? Because again, you're trying to avoid probate. The last thing you want is to have this person be the beneficiary. They've died. You haven't identified anybody else. So what's going to happen? It's going to go to their probate. It's not going to get resolved unless you have a backup plan. What happens if they don't survive you? Then what happens? Who gets it? And it may be a charity, but you want to close that gap so that somebody else doesn't end up in probate. Per stirpes, and does somebody else become the beneficiary? So normally what we do, if you have children and they have their own children, so you have grandchildren, you would say, okay, well, I'm going to give it to my children per stirpes, which means if they don't survive, then it goes to their children equally. Okay? That's just a term of art, but that gets you to the next level. Again, back to the previous one, if your children and your grandchildren have a terrible accident, you want to have a concession for what happens. Does it go to your other children? Does it go to someone else? A relative, an uncle, what have you. How do we make sure that everything we want in the trust gets put in the trust? You need to put it there. Now, we've talked about deeds, and those are fairly easy. You do a transfer, a deed of gift, you put the property in the name of the trust. A vehicle, you do the same thing. You transfer the vehicle from you to the name of the trust. Since 9/11, we are all impacted by all of the new banking regulations that are now in place. You can't just name your trust as a beneficiary anymore. There was a time where you could. You actually, in most banks, have to open up a trust account as opposed to naming the trust as your beneficiary. So you would close your regular account and you would open a trust account. Some banks in the Virgin Islands do not do trust accounts, others do. And then that trust account then takes care of all of your expenses, etc. But then there are other things. So you, like I said, we take pictures. If you take pictures of your jewelry and you identify who gets them, that's the equivalent of putting it into your trust. Anybody can open up your trust, look at it and say, oh, okay, that necklace, the Sagittarius one, that one goes to this grandchild. It's not a question anymore as to what your intention was. And when we talk about like business interests, things like that, you would literally transfer ownership of that business, whatever portion of it that you have, into your trust. So you no longer own that business. Now your trust owns that business. So then that doesn't have to get probated. So these are the mechanisms by which you put literally everything that you want to put, including Granny's Sugar Bowl, into the trust. And sometimes what I've had to tell people is you have to call your institution. If you have a CD or you have a 401k or any other kind of investment account, you literally have to contact each one and ask them, what do I need? And the other critical component these days is asking them, if I don't put the trust as the beneficiary, because it may create a tax consequence, then how many beneficiaries can I name so that you make up for the contingencies? If that one predeceases, then it goes to this one, sort of thing. There's a lot. Each of these institutions has their own form. You can't just fill out a form, you have to fill out their form. And you have to be very specific about how you write down who gets what in some of these scenarios. I had one myself recently where I had a nonprofit that was supposed to receive a small portion of something. And when the investment person got back to me, they said, oh, well, you know, if this person predeceases, then all of it goes to the nonprofit. And I'm like, time out. No, that wasn't the plan. You have to tell me how I'm supposed to fill this piece of paper out so that they only get the portion that they're supposed to get. So you have to ask the questions and get the right paperwork so that you know that what your desire and intention is actually gets carried out. So sometimes there's a lot of background work. You've got to go ask people for forms and make sure that they get them, and they have all kinds of new confirmation systems so that you have to upload them into these portals and do all of this special stuff to accomplish your objectives. But it's critical that you do, because if you don't, you're leaving something behind that becomes a probatable issue. Okay? Bank accounts, the reason why I highlighted that again is because with the banking regulations that we have today, you have to be specific. One of the things I recommend that you ask the bank is, when I die, does the beneficiary just have to bring you a death certificate? And if that's what you are trying to accomplish, whether it's pay on death or whatever the account the banking institution uses as its process, you do not want to have that beneficiary walk into the bank and be told you have to go probate this. And I've seen it happen. So unfortunately, 5 years from now, that pay on death language may go out the window, and they may have invented something else. You have to stay on top of these institutions and make sure that your paperwork accomplishes what you want. And periodically you need to follow up and make sure that everything is in place the way you want it to be, so that your desires are actually carried out. And so it's tricky. They're not going to send you a notification and tell you our policy has changed. You now have to use this piece of paper. If it was only that easy. After you have a trust, make sure that you have a living will, a power of attorney for health care. Make your funeral wishes known in as much detail as possible. I guarantee you that the people that are going to be carrying these things out for you want to know what you wanted. I have watched more people just anguish over what would mommy have wanted. And I tell people, please, just tell them what you want. Don't leave it up to them, because it's everything else they're dealing with at the time, having to make these decisions is even harder. Spell it out as best you can. Pour over will. We were talking earlier about wills and whether you have a will if you have a trust. You absolutely have a will if you have a trust. We call it a pour over will. Basically, it says whatever I left out goes in the trust. The trust will tell them where everything goes. You could inherit something. I had this happen recently. No clue that you're the beneficiary of something. Clearly it wasn't in the trust, but now they're marching off to probate this asset. If you have a will, at least it helps to speed up the process, because it says, put it in the trust. Okay? So you always have a pour over will when you do a trust, because it's possible you could leave something out. As many times as I tell people, after you've put your trust together and your trust is in place, please don't buy anything outside of the name of the trust. You've just defeated the whole purpose if you go out and buy a car in your name or buy a piece of property, and I've seen it happen. I can't tell you how many times. And then what happens? People end up in probate. They've got a perfectly good trust, but they bought something and didn't buy it in the name of the trust, and off they go to probate. Okay? It happens, trust me. Review your trust. Every 3, 5, 10 years, review it. You may have changed your mind about those loved ones. They may have already passed away. You may have decided that they don't deserve what they're getting. Or you may decide that somebody else who wasn't even born yet is now the person that you want to. It doesn't matter. Just revise. It's very easy to do an addendum, but you want to stay on top of it. You don't want to be in a situation in which all of the people that you've named as beneficiaries are all gone and you haven't updated things. Another thing that has happened, and I've seen this quite a bit lately, is lending institutions change your account numbers. Like, you may not even realize it because it's still the same lending institution and it's still an account. But they've changed the numbers because their numbering system changed. So your trust is very specific. It's got all of this information about this account number, but the account number's changed. Or they've reinvested with another institution. It's not even the same company. It's a whole different company. So all of that stuff you said about Ameriprise, it's not even Ameriprise anymore. It's now something else. You want to revise, update, make sure that everything is current. If you've sold something, what I usually tell people is the most important thing is what you buy, not necessarily what you get rid of. But when you do these amendments, if you know that things are gone, rather than having people looking for things that have already been sold, you can throw into the amendment the things you don't have. You got rid of that 30-year-old car and you got a new one, put the new one in and just tell them so that they're not chasing all over the place looking for that car that doesn't exist anymore. Just another line item that says this car has been sold and you're replacing it with this one. Simple. Assets may change. You may decide that you want to do something else. Tax laws may change. So the implications of what you're doing may change, and you may need to make some adjustments to try and avoid some taxes. And just stay on top of it. It's not something that, oh, finally, it's done, I can put it away. Please don't just put it away. Take it out, look at it, make sure that things are current. It's amazing what can happen in 3 to 5 years. It's truly amazing. And we might be finished. Next. Questions? Yes. Transfers of deeds on death. This is a very fun topic for me because I have a different perspective.
Anna, could you repeat the question? Could you repeat the question because we didn't hear?
Okay. Mike? Or just say it and I'll just repeat it.
Yeah, so if you have a transfer of deed on death, I was looking it up, like for a vehicle, and you still owe money on the vehicle, and if you were, like, maybe the age where you can die tomorrow. So you have to contact the bank or that you have a loan with and ask them if it's okay for you to put that transfer on?
Okay, so the question is, if you have a transfer of death on deed and you have a loan with the bank, do you have to notify the bank about the transfer? So I'm going to double this question up with respects to a mortgage on a piece of property for a trust as well. You notify the bank that you have this provision. You can send them a copy of it. It doesn't change anything. It's still going to affect that vehicle or that piece of property, but you're going to want to keep them abreast of what you're doing. And just as a caveat to that, when you transfer your vehicle to your trust, you want to let the insurance company know that you've done that so that it has the right name. You know, they're not big deals in terms of like, they're not going to tell you, no, you can't do that, but you want to make sure that the paperwork matches. I do want to say something on transfer on death. It's a great concept, but what happens if that person predeceases you? And that's the concern that I have with respect to the provision. Obviously, if everything goes as planned, your children will live longer than you will, or your grandchildren, whoever you've designated that are younger than you, but I don't have a crystal ball anymore. I don't know if they're going to be there. And I'm not 100% clear on how much you can change that transfer once you've done it. Now, we may have